implemented, and then we monitor and enforce these agreements. So our FTA partners have to put into place laws that will effectively protect IPR. And these FTAs include a state-of-the-art IPR chapter. And just to give you an example of some of the provisions that are in there, it criminalizes end-user piracy. We provide strong deterrence against counterfeiting and piracy, and that's an obligation to put into place penalties that are truly deterrent, not just some minor fine which infringers will just assume is part of the cost of doing business. We ask in our FTA partners that they put into place truly deterrent penalties. Also, we have provisions in there where enforcement officials have the authority to seize infringing goods, have the goods forfeited, and then eventually destroyed. Oftentimes, we found that in countries where there is no such authority, once goods are seized, they seem to disappear, and then they enter the channels of commerce again. And so we want to ensure that these infringing goods are actually destroyed at the end of the day. Also, in order to ensure that enforcement officials have the power to conduct effective enforcement actions, we ask that our FDA partners put into place a provision on ex officio authority, and that is for customs or police to have the authority to carry out enforcement actions where the right holder doesn't necessarily file a complaint. So moving on to the next trade tool, our Special 301 review. The Special 301 is USTR's annual report on international IPR protection. It's used to encourage specific trading partners to place a higher priority on addressing identified IPR problems. Each year, we do a catalog of a country's IPR regime and identify specific problems that exist in various countries, or our right holders doing business in those countries have found to be a problem. They bring it to our attention, and we do an assessment, and we do this in consultation with other government agencies, and it's a quite extensive process. And at the end of April, we issue a report. And this signals to the world and foreign investors that it tells them how high a priority a country places in IPR protection and how friendly a climate it is for their intellectual property rights. This is an effective tool. We found that countries actually care very deeply about their placement in the Special 301 report. And so this mechanism is a great tool for our bilateral engagement with a number of countries. Next, the World Trade Organization. The World Trade Organization is a great forum for us in that it provides us different contexts for us to engage with our trading partners. There is something called, as many of you may know, the WTO accession process. And if a country wants to join the WTO, they have to bring their laws up to the level of the WTO agreements. And so we engage with our trading partners to ensure that they're there, or very close to there, before the United States will sign off and let a country join the WTO. So this is a great mechanism for us. Secondly, there's something called the Council on Trade-Related Aspects of Intellectual Property Rights, or TRIPS Council. And this group gets together regularly and gives us an opportunity to review a country's IPR regime. So if they're falling behind in their obligations, this is a place where we can identify the problems and try and work with them so that they will quickly fix the problem that there is. Thirdly, there is something called the Wto Dispute Settlement. This is a forum to litigate very discrete issues where we aren't able to resolve the problem with the country through dialogue. As some of you may know, we filed a IPR case, a WTO IPR case, against China not too long ago. And we are hoping to have a decision from the WTO panel on this case in the fall sometime. So the United States actually is one of the more regular users of the WTO dispute settlement mechanism, and